thank you so much for coming, and thank you for your service all these years to people with disabilities. I get your newsletter. It's called Social Security Newsletter, and Jeffrey will let you know how to get it afterwards. So Jeffrey Rabin is an attorney licensed in Illinois in 1980. He has focused his law practice in the representation of people with disabilities seeking benefits under the Social Security Act. He founded Jeffrey A. Rabin and Associates Limited in 1988, and he has represented clients nationwide at all levels of the administrative process and in federal courts, that's been really amazing. A frequent speaker on Social Security issues, Mr. Rabin has lectured nationwide to a variety of community, legal, insurance, and government agencies. Jeffrey, I'm gonna leave you now, and I'll be back in about 50 minutes.
All right. And Jim, you can see my screen, my PowerPoint okay right now?
I definitely can see that. Yep.
All right. Well, thank you.
Take care.
Thank you for the introduction, and thank you everybody for coming to this session. So my name is Jeff Rabin, and I'm an attorney, and all I do in my practice is help people who are disabled and are trying to get benefits from the Social Security Administration. I became a lawyer in 1980 and got stuck with the Social Security work in that first small office because none of the other lawyers wanted to either deal with the clientele or the bureaucracy. As time went on, I found I liked the clientele and I liked the bureaucracy a whole lot more than I like other lawyers. And the nice thing about my work is I don't have to deal with other lawyers. It's me, the client, the judge, and off we go. I did my first disability case in 1981. Actually, my third disability case ever was a reflex sympathetic dystrophy case. And back then in 1981, the name CRPS didn't exist. And in fact, some of the doctors were still calling this causalgia back then. And it was one of the first cases that really got me motivated to learn more about this area of law and pursue it. And eventually in 1988, I set up my own law firm just to do this. I've known Jim Broach in this agency for many, many years and have worked with many patients from this group and am pleased to be able to be here to support it. Now, my normal program on disability law takes about 90 minutes, and we have half of that today. So we are going to sort of skip around a little bit and sort of hit highlights, but please put questions down in the chat box and we'll try to get to those at the end. And the slides, even if I don't talk about them all, cover all the material that you need to know in order to understand, number one, whether you should be applying, and number two, how to have your claim approved. So we're going to talk a little bit about what it means to be totally disabled. What does that phrase actually mean? We're going to talk a little bit about what SSDI is and what SSI is and what the differences are, because those differences are really critical for your family planning and possibly for your future. We're going to talk about how Social Security thinks about cases and, most important, what the keys are to having an application approved. And then if we have time, we're going to talk a little bit about what happens after an application does get approved. See, Social Security was never intended to support anybody. Social Security retirement was never intended to support senior citizens. It was intended to supplement family savings and family support. Not for all clients, but for many, many of our clients, we view disability as a time program, giving people time to treat, some basic financial support, time to recover, time to retrain, and ultimately time to return to work. And there are good return to work incentives built into the Social Security law, but they're a little confusing. And they're often scary because you had to work so hard to get your application approved. The materials in the handout will explain those rules, and I can certainly answer questions at the end if we don't have time to cover all of them in detail. Before we get into a lot of this, let's talk a little bit first about COVID-19. The Social Security offices are open. Well, let me rephrase that. The Social Security services are open. Work is being done. The offices are closed. So work is being done at home and it is not as efficient as it was when the staff were in the offices. For example, our cases at the initial application level, the first level of review after you start a case, typically take 90 to 120 days, maybe 150 days. We're at 6 and 7 months for many cases, and they haven't even really been developed yet. So the process is moving forward, but a little slower. They're starting to catch up a little bit because they're finally figuring out ways to do the consultative examinations by telehealth visits and things like that. Hearings are going ahead, but in a much modified form. The hearing offices are closed, so now they're doing hearings by telephone. In the beginning, we were very, very reluctant to do many hearings by telephone, but as time gone on, we found, number one, we have to, or our clients are going to be delayed for months and months and months. And second, it actually hasn't been that bad a process. They are talking about switching to a video hearing system using Microsoft Teams. Who knows if that's really practical for the general population nationwide, but Social Security is investigating that. So COVID-19 has not put a stop to the system, but it has slowed it down. Okay, let's go to the next slide. Let's talk about what it means to be totally disabled. In order for me to get a client SSDI or SSI benefits, I've got to prove the existence of a medically determinable impairment that has lasted or expected to last at least 12 months or result in death, bruises, and symptoms of severe ability to perform any substantial gainful activity available in the national economy on a full-time basis. Now, I said that really fast because that's a lot of legal mumbo jumbo. Let's talk about what it really means. In order for me to get benefits for a client, I have to be able to prove that my client is suffering from symptoms which so impact their day-to-day functioning that for a period that has lasted or expected to last at least 12 months, they're unable to perform any type of full-time work available in the national economy. Now, I said that very carefully. I did not say that I have to prove my client has CRPS or cancer or any other medical problem. The focus in a disability case is not on the diagnosis. The focus in a disability case is on what are the symptoms from that diagnosis and how do those symptoms impact this person's ability to do simple full-time work activity. I get calls all day from people who say, Mr. Rabin, I have sugar, diabetes, and high blood pressure, and I want to get SSI. And my response is always the same. So what? Take your medicine, watch your diet, get a little exercise, and go to work. Now, those are really serious medical problems. And my father actually passed away from untreated hypertension. But typically, those medical conditions do not produce symptoms which impact on somebody's ability to function. People with cancer work, people with multiple sclerosis work, people with mental illness work. So the focus in a disability case is not on whether you have a diagnosis. The focus in a disability case is on the evidence of the symptoms from that diagnosis and how those symptoms impact your ability to function full-time in a job setting. So if I get somebody that calls me up and they say, Jeff, I have a physical medical problem, I have a bad back, or I have a bad heart, or I have a breathing problem, my questions are, okay, that's terrible, but what are the symptoms from those conditions? And how do those symptoms impact your ability to do the physical motions of a job? Sitting in a chair, standing, lifting, reaching, pushing, pulling. Those physical motions involved in every single job, how are they impacted by the symptoms from whatever that physical medical problem is? If somebody calls me up and they have a mental impairment, major depressive disorder, severe anxiety disorder, PTSD, agoraphobia, schizoaffective, the most common call on the mental side we get is bipolar disorder. What are the symptoms of that mental impairment? And how do those symptoms impact on the ability to do the basic mental motions of work, understanding and remembering simple instructions, interacting appropriately with supervisors and coworkers, dealing with work stress and work change. Those simple mental motions that are involved in every single job, how are they impacted by the symptoms from whatever label the psychiatrist has put on the person? See, Social Security will almost never deny the diagnosis. Guy's got a scar 6 inches down the middle of his back. He had a back fusion. Social Security's not going to say he didn't. What they're going to say is, so what? What are the symptoms after the back fusion? And how do those symptoms impact his ability to function full-time in a work setting? And they call that your residual functional capacity to perform work-related activities, RFC, what you can still do on a full-time basis despite your medical problems. And Social Security develops an RFC for every single person that applies. In fact, by the time you get to a judge, you might have 2 or 3 or even 4 RFCs in your file from different Social Security doctors that have reviewed the medical charts. And then they take that RFC and they apply it to the mythical world of work. So one of the things that people have to understand, this law is not a jobs program, nor is it an aid program. It does not matter if you can get a job. It does not matter whether you know how to do a job. It does not matter if you need help. It does not matter if you can't get to a job or if you're uninsurable or if the jobs that you can do don't pay a living wage. None of that is going to be considered in a disability case, especially for people under 50. At 50, a little bit if you don't have a GED education. At 55, a little bit more. But those real world problems are not the focus in a disability case. So let's take an example. Let's take a 48-year-old Chicago-based union carpenter. In Chicago, a carpenter in the union makes about $43 an hour in salary plus benefits. He's climbing the scaffold tips, he lands, he fractures a couple of vertebrae, he herniates a disc in his low back, and he needs a back fusion. He is never going to be a $43 an hour carpenter again because he's not going to be able to bend and saw all day or throw 2x4s over one shoulder and climb a scaffold with the other arm. But that's not the test. Social Security is a total disability test. So in order to get benefits for this young man, I have to prove that he cannot function as a ticket taker at a movie theater. Wear a little blue jacket, sit or stand on a stool, change positions at will, tear tickets in half, door number 2, enjoy the show. Ticket taker at a movie theater, coin changer at a self-service gas station, shoebox packer in a shoe store, washing machine unloader in a laundromat. Social Security has used all of these kinds of jobs to deny my clients benefits in the past. A couple of years ago, I represented a woman who had been a cardiac intensive care nurse at a downtown Chicago hospital, and she developed rheumatoid arthritis and ended up with 2 claw hands. Social Security denied her application, stating that she had the RFC to be a bicycle rental clerk. Back when you can help substance abusers, and we can't anymore, I was representing a man who was living in a 1-year lockdown facility to try to help people with long-term chronic substance abuse problems. They denied his application, saying that he had the RFC to be a bank vault security guard. Now, when I told Henry the heroin addict they wanted him to guard the bank vault, he said, "Mr. Rabin, I wish how I wish." The point is, Henry was never going to guard the bank vault, and my nurse was never going to rent bikes, but that's not the test. For me to get them benefits, I had to prove they could not function full-time at those jobs. If I could, I won. If not, I lost. So if you want to write down one word that will summarize everything we've talked about so far in determining your viability for disability benefits, you want to write down the word DO, D-O. Social Security disability claims are not focused on what your medical diagnosis is. They're focused on your symptoms and what you can do on a full-time basis despite those symptoms. Now, this basic law, proving the inability to function full-time at any type of work activity, is applied to two different programs. The first program is called Title II of the Social Security Act, Social Security Disability Insurance, SSDI, Workers' Disability, Regular Disability, we'll call it SSDI. The second program, Title 16 of the Social Security Act, or SSI, is Supplemental Security Income, and that one we're going to call SSI. So we have SSDI, SSI. Let's first start by talking about SSDI because it's the more comprehensive of the programs. SSDI has two requirements. First, you must be totally disabled. That's the medical test. Second, you must have worked and paid FICA taxes for at least 20 quarters of the 40 before onset of disability, and you must have paid FICA taxes for at least 40 quarters in your life. See, this is an insurance plan, Social Security Disability Insurance, and it is no different than your car insurance, your homeowner's insurance, your health insurance. Now you're thinking, I know I pay my car insurance to State Farm, and I know my health insurance is paid for by the boss. I don't ever recall writing out a check to Social Security Disability Insurance, but every one of you that ever worked has. Now, the deal my staff says to me as the boss is for not quite enough money, they work too many hours and under too much stress. Okay, it's a normal boss-employee relationship. The problem is whatever deal you made with the boss never kept it because not one of you has ever gotten a paycheck for what the boss promised. And why? Every time you've gotten a paycheck, the paycheck has a stub. Now, the top line on that stub says federal withholding. The money goes off to Washington, D.C., and it pays for the Army and the Navy and the Smithsonian Institute. And then I usually throw in a political joke, but this year there's not a snowball's chance I'm making a political joke right now. Bottom line on your check stub for most states says state withholding, unless you're fortunate enough to be in a state that doesn't have state income tax. We do here in Illinois. So that money goes off to Springfield, Illinois, and truly only the Lord knows what they do with it down there. But we know not enough of it goes for Medicaid and not enough of it goes for public education to give people better opportunities. And then you've got the lines in the middle for the money that goes over the rainbow to the land of FICAville. Now, a few of you in the audience may have a little gray like me in the beard and remember when our checks actually said FICA. They don't do that anymore. Now it's broken down into two lines, OASDI and Medicare. OASDI, Old Age Survivors and Disability Insurance. And that money is taken out of our paychecks and it's matched by the boss. So every dollar in FICA payments that's pulled out of your paycheck, the boss reaches into her purse, she matches it dollar for dollar, and the money goes off to the Social Security Trust Funds. And there's 3 of them. So what you have to understand is you don't have money at Social Security. You do not have an account to draw upon. You have a right to make a claim against the trust funds. The big one that eats up almost all the money is the Social Security Retirement Trust Fund. And that's the one that pays benefits to our parents and grandparents and aunts and uncles who've reached retirement age. Then you've got a little one off to the side, and little is relative because we're talking in the billions here, and that's called Social Security Disability Insurance. And another little one off to the other side, and that's called Medicare. And that's how these programs are funded. You work, the FICA payments are pulled from your check, the boss, she matches it, the money goes off to the trust funds, and then are immediately paid out to the people who are currently getting benefits. Whatever is then left over at the end of the month that isn't used for current beneficiaries is loaned to the US Treasury, so they can lie to us about the federal debt, because if they actually factored the real federal debt plus the obligations of the trust funds, nobody would have any faith in our government anymore. To qualify for SSDI, you must meet a 2-part FICA test, 40 quarters or 10 years in your lifetime, and 5 of the 10 years or 20 quarters in that time period prior to the date you became totally disabled. If you've worked and paid your FICA taxes and you're totally disabled, you'll get a monthly check. The amount of that check is a computer formula based upon your age and how many years you've worked and how much you've paid into the system. Dependents get benefits until age 16 or through age 18 if they're still in high school. You get a cost of living adjustment that just came out, hot off the presses. The COLA for 2021 will be 1.3%, far less the increased costs of medicines, medical care, and housing for most retirees and disabled. You also become Medicare eligible 29 months from the onset date. This is said lots of ways on the street, often wrong, so let me explain. This is October of 2020. You're going to learn a lot about me tonight. One of the things is I'm a really big klutz. So I go outside to fill the bird feeders, and it's dark already, and I trip and fall and bang my head. My wife gets concerned. She rushes me over to the hospital, and they say, oh my God, he's more brain damaged than he was when he started talking at the RSDSA conference. And I'm totally disabled from brain trauma. SSDI, no matter how sick I am, has a 5-month, what they call elimination period. We call it a starvation period. So I would not get a check for November, December, January, February, March. My first check will be April 2021. Medicare will kick in April 2023. 2 years, 5 months from the onset of disability. 2 exceptions to that rule. Number 1, if you're on kidney dialysis. Number 2, if you have Lou Gehrig's disease. No rational, reasonable explanation for those 2 exceptions other than good lobbyists. Now, a couple of national agencies and associations, including NAMI, the National Alliance on Mental Illness, that I'm very involved with, along with some of the legal bar associations, our group and Oscar, are putting together legislation to eliminate the 5-month waiting period and the 29-month Medicare waiting period. We'll see what happens after the elections, and maybe I can work with Jim and get RSDSA to support that also, because truly quicker access to Medicare would help people a great deal. So those are the highlights of SSDI. Totally disabled, worked and paid FICA taxes. Let's talk about SSI. SSI also has 2 requirements. Number 1, you must be totally disabled. Number 2, you must be indigent. Indigent for SSI purposes means no money coming into the household other than possibly TANF benefits, and less than $2,000 in non-excludable resources. What do we mean by non-excludable resources? You're allowed a house if you're living in it. You're allowed 1 car because you have to go to the doctor and the hospital and the pharmacy. They won't value those. They won't value the clothes on your back, but they will look in your wallet. They will look in your purse. They will look for checking accounts, savings accounts, 401ks, 203Bs, cash value life insurance, any asset that can be converted to cash. even if you have to pay a tax and a penalty to access it, counts against the $2,000 limitation. So this is a program for people who are permanently and totally disabled and have very limited financial resources. If you have that and you're living independently, in 2020, your benefit is $783 a month. If you want to note it down, the benefit in 2021 for SSI with the cost of living adjustment will rise to $794 a month. Now, one of the things that's a huge issue in this law, and I have a whole discussion of it that I'm not going to give right now because of our time limitation, is deeming. Deeming says what belongs to me belongs to my wife, Sherry. What belongs to my wife, Sherry, belongs to me. And what belongs to the two of us would belong to our minor children if we still had any. So what typically happens, and I've averaged this phone call 2, 3, 4 times a week, every week for 30 plus years. So if I'm one lawyer in one office getting this call or email or online chat this frequently, if you expand this nationwide, you see how bad this problem is. The bottom line is, in the United States of America, stay-at-home parents get screwed because that stay-at-home parent stops working, in quotes, later becomes disabled. 20 years later, say they're in their 40s now or early 50s, can't get SSDI because they've not worked 5 out of the last 10 years at FICA jobs, and can't get SSI because their spouse's assets and income are deemed that, and therefore they're not eligible for SSI benefits because they're not indigent. This causes huge, huge hardships to many, many families. And there's very little that we can do in those situations, and it's very frustrating. Okay, so we have 2 primary programs, Title II or SSDI, Title 16, SSI. There's some subsets there. We can answer questions on those later if you want. Again, I'm trying to be mindful of our time. Let's just talk a moment about how Social Security thinks about cases. In the regulations, they have something called the Sequential Evaluation Procedure. And this is an analytical framework that's used by every single decision maker at every single level of the process. Everybody uses the same analysis. But I'm a roofer's kid. My dad was a roofer. My grandpa was a roofer. My brothers are roofers. Excuse me, I have a virus that is not COVID, and that's why I'm coughing so much. And I apologize for that. So I can only say sequential evaluation procedure twice in a day, and my tongue goes on strike. I talk about climbing the ladder, because that's how I grew up, with the ladder banging in the back of my dad's Pontiac and the smell of hot tar, which to me is still the greatest smell in the whole world. The first step on the ladder, actually the ground floor before you even get on the ladder, is this a compassionate allowance case? Compassionate allowance claims are claims that Social Security decided they pay every single time. And if they pay every single time, why should they make people go through the apply, deny, and appeal process? These are very specific conditions. You can Google them or call my office if you want to know if a particular condition is a compassionate allowance. Most of these are conditions that you've never heard of. They're very long names, but some are a little more obvious: brain cancer, Alzheimer's, Huntington's disease, lung cancers that are advanced. These are usually death-causing conditions. They're not chronic conditions like RSD or CRPS or lupus or those kind of things are not ever compassionate allowance cases. Assuming you don't have a compassionate allowance case, the next question is, are you working or involved in substantial gainful activity? This year, work is defined as any full or part-time activity that generates at least $1,260 gross in a month. So if you're doing full or part-time work and making $1,260 gross in a month, and there's not one of a few very narrow exceptions available, you're going to be considered working and involved in SGA. In your case, is denied at step 1. Assuming you're not working, we go to step 2 on the ladder, which asks, is there evidence of a severe impairment? And in this case, severe means a condition which at least minimally impacts on function. The best example of defining this is to give you an example of a non-severe impairment. And that's a seizure disorder controlled by medications. Now, epilepsy is a really serious condition. But you remember back in the very beginning, we mentioned that it's not about diagnosis, it's about symptoms. And if that seizure disorder is controlled by the Tegretol or the Dilantin or the phenobarbital, so this person is no longer suffering seizures, then it's not a severe problem for work purposes. It's a serious medical problem, but it's not producing symptoms now that impact on work function. And that case gets denied at step 2. Step 3 of the ladder asks, does this condition meet or equal the listings? And this is pages and pages and pages and pages in the regulations of different medical problems and very specific medical criteria. And if you meet that medical criteria, you're considered disabled and unable to work, and benefits are approved. It's a very high threshold. We've had over 50 clients in our office die, and Social Security said they didn't meet or equal the listings. Unfortunately, there's no listing for CRPS. So if that's the primary medical problem, we can't get approved at this 3rd level. So what do we know so far? We know our client isn't working at step 1. We know they have a severe impairment that impacts function at step 2. We know it's not so bad that it meets the listings at step 3. We go to step 4, which says, remember the RFC, residual functional capacity, what this person can still do? Are they able to function at any of the types of jobs they've had in the last 15 years? Now, that doesn't mean can they get those jobs. Jobs might be going out of the country. That's not the test. The test is, what kind of work have they done in the last 15 years? And do they have the RFC to function at that kind of a job? If they do, we lose. If we can prove they can't do their past work, what do we know? We know they're not working at step 1. We know they have an impairment that impacts on function at 2. We know it doesn't meet or equal the listings at 3, but we know it is so bad that it limits their RFC that they can't do old work. Now we go to the last step on the ladder, 5, considering their age, education, work skills, and most important, their residual functional capacity. Are there other kinds of jobs that this person can function at on a full-time basis in the national economy? If I can prove there are not, I win. If I fail and Social Security identifies jobs, I lose. Every case follows this analysis. I don't care if they're approved by or handled at the adjudicator level, the judge level, the appeals council, or federal court. Everybody follows this ladder. All right, let me go on here. Why am I not? There we go. I'm going to skip a couple of let's talk here. So actually, let's go to here. So Social Security, even though there is not a listing for chronic regional pain syndrome, did acknowledge that it's a real problem. And that was done in 2003 with what's called a Social Security ruling. And this provided guidelines for Social Security adjudicators and judges, and it is binding for how to consider CRPS. Because when I was handling these cases in the 80s and the 90s, it was brutal to get a judge to say this is a real condition. So the key things for us in this ruling, and you could Google it to have a copy for yourself, or I can send it to you, is Social Security does recognize that this is a real disease. And they say the problem with it is you can't prove it. I can't prove CRPS. More important, I can't prove pain. More important than that, I can't measure pain. Does somebody have 3 degrees of pain or 6 degrees of pain? If a client's sitting across from me in my office or on a Zoom call with me, I know they're not having 9 or 10 degrees of pain because they're not in a hospital on a Dilaudid drip. But how is a judge supposed to know how much pain they have? And that's the problem in any chronic pain case, whether it's CRPS or fibromyalgia, or even just a bad back case. What Social Security ruling does is it gives us some indications of what to look for in the medical charts. So for CRPS, the judges want to see evidence of swelling or skin changes or hair loss or osteoporosis or involuntary movements. They're looking at a longitudinal view of the records, and we're going to talk about what that means in a few moments. And they can also look at third-party sources, but they're not the key. What is the key? How are we going to prove this case that doesn't lend itself to proof? And let's go now to the most important slide in the program, and that's this one. 3 rules that must be followed if we're going to get your application approved. Rule number 1, you must be going to the doctor. You must be going to the doctor. You must be going to the doctor. I cannot say it enough. These are medical cases that turn on medical charts, medical findings, and medical observations. When a new client meets with me, we tell her right away, what you say is not evidence because you want the money. As far as Social Security is concerned, you would testify under oath that I still had a full head of curly brown hair if that would get you $1,000 a month. What your husband, partner, next door neighbor, son, priest says, none of that is evidence because they like you. The only thing that's evidence in a disability case, and the only thing that a Social Security judge is going to consider, are the charts of the doctors. You sort of think of it, and I hate this analogy because I've honestly never shot a gun in my life, but people like to think of their lawyers as their gunslingers, going out and shooting the opposition to get them their help. Well, I wouldn't know how to shoot a gun except maybe a rifle because I like John Wayne movies and I've seen him do it. I wouldn't know how to shoot bullets. I shoot MRI reports. I shoot physical therapy evaluations. I shoot Beck depression inventories. I shoot the observations of the pain medical specialist. Those are my bullets. If you're not going to the doctor, I have no evidence. If I have no evidence, I have no case. There is no excuse. Social Security will not understand that Medicaid doesn't provide enough benefits or it's COVID, so you can't see the doctor. You can telehealth with the doctors now. All doctors are seeing people on telehealth. You must be going to the doctors. Rule number 2, there's a right way and a wrong way to go to the doctor. I told you all that I'm a roofer's kid, and I was very lucky. My brothers and I were blessed. We had incredible parents. They've been gone for many, many years, but we learned a lot. And I learned a lot from my folks, especially my dad, who's still my hero. One of the things about my dad is he was a tough guy. And he'd be up there on the roof, and he'd be using his hatchet, and he'd be chopping up the old roof. And remember I told you earlier how I tripped on my feet going out the door to fill the bird feeders? Well, I got that klutziness from him, and whack, he takes his hatchet, and he hits his arm, and he puts a gash in his arm. Well, that job had to be finished. He wasn't going to stop, so he'd spit on it. He'd put a glob of tar on it to close it up. He'd finish off the job. He'd go home. My mom would see him. She'd say, "Oh, Bobby, you did it again." But my dad never complained. He never complained. He took what life gave him and made the best of things. The other thing about my dad, he was the world's biggest flirt. And he flirted all the time. And I learned from him how to do that. And I'm pretty good at it. My first wife had a problem with it. My current wife gets it. It's much better. Today, I'm going to the psychiatrist. And I'm getting a little old. She's very young. She's got a nice smile. She's very smart. I respect her, but I'm a flirt. So today's my day to go to the doctor. And I do what every one of you do. Today's the day I take a shower and I put on a clean shirt and I trim what can be trimmed. I pat down what's left to be patted down. And I walk into the doctor's office and she says, "Hey, Jeff, how are you today?" And I say, "I'm okay, Doc, how are you?" And I just lost my disability case. Because what does she chart? Well-groomed, nice man says he's okay. Next month I come in, and now I'm not looking so good. The clothes are a little wrinkled, my eyes are red. I have this thing they call a flat affect, which means I look depressed. And she says, "Jeff, any new symptoms? Maybe we need to adjust your medications." What do I hear? Adjust my medications? I don't know how many of y'all are either dealing with mental health issues or working with people that have had mental health issues, but the last thing somebody wants to hear is to change their medicines. I've been on Prozac. I've been on Zoloft. I've been on Wellbutrin. I like my Lexapro. I don't want to do this medication roller. "Oh, no, Doc, really, it's just been a bad week. The dog pooped on the carpeting and the kid had a D on his report card. Really, there are no new symptoms." What does she chart? Jeff says no new symptoms. Judges read those notes. Jeff says no new symptoms. Jeff says he's okay. Jeff says things are stable. Okay, go to work. Case denied. I lose cases because my clients are not describing to the doctors how bad their day-to-day life is. CRPS can be devastating, but if you can't get out of bed, you've got to be telling the doctors. If you need your husband to tie your shoes, you must be telling the doctors. If you miss your daughter's dance recital, you must be telling the doctors. If your concentration is so messed up by that pain that you can't watch a TV show, you must be telling the doctors. If your fatigue is so bad from just coping with everything and you can't function and wash dishes or make dinner for your family, you must be telling the doctors. If it is not in the charts, it does not exist. And those of you that have lost cases in the past, you've lost cases because your charts were not showing how bad your symptoms are and how bad they're impacting your day-to-day life. Now, let's be fair to Social Security, because we can't prove pain and we can't measure pain and we can't prove fatigue and we can't measure fatigue. They have to have some way of deciding whether you're telling the truth or not. And the way they do it is by how consistently you're describing your symptoms to every single doctor. So if you want to write down a mantra to remember, it's every symptom, every doctor, every visit. I don't care if you're going to the back doctor, you talk to them about the pain in your feet. I don't care if you're going to your OBGYN, you talk to them about the pain in your hands. Whatever it is, the more consistently it's described across the board, the more believable it becomes to Social Security. Third rule, there is a clear relationship between chronic pain, chronic impairment, and depression and anxiety. And they interact. But I can't prove depression or I can't prove anxiety if you're not seeing either a psychiatrist with a good counselor or alternatively a good PhD or PsyD psychologist. And you have to be talking to them about how your symptoms impact your concentration and your ability to interact with other people and to deal with stress and to deal with change and to take care of your day-to-day life. All of these are very real problems, but if you're not talking about them, number one, the doctors can't help you, and that's most important. And number two, they don't get charted. If they don't get charted, they are not evidence. These are the keys to having a disability case approved. Now, since we can't meet a listing, one of the key ways to prove disability is proving the inability to sustain activity. In a different Social Security ruling, 96-8P, Social Security defined work as the ability to function 8 hours a day, 5 days a week, day after day after day after day. And if we can prove through those medical charts how simple activities like going to the grocery store or vacuuming or walking the dog take your pain level from that manageable 3 to 4 because you're not doing anything to 6 or 7 and knock you out for 2 or 3 days, that's how we prove the inability to sustain activity. And this is our major theory in any CRPS case that we handle anywhere in the country. I'm going to skip ahead just to this page, and then I'll stop for questions. Many of you are already getting disability benefits. You will all be reviewed. Everybody gets reviewed. You never know when, and you never know how it's going to happen. But the test in a medical review is there evidence of medical improvement sufficient to allow this person to return to work? It's a medical improvement test. They start with your doctors. So what happens? I'm representing Joe, and Joe is stubborn, and I yell at Joe, go to the doctor, go to the doctor, go to the doctor. He goes to the doctor, we win his case, he gets his checks, and he stops. He stops because the doctor says, I can't help you anymore, or the doctor leaves, or he just gets frustrated. Well, a year later, he gets a call from a Social Security adjudicator saying, hey, I'm doing a continuing disability review, and the test is there evidence of medical improvement? Who's your doctor so I can see? And Joe says, well, I haven't been to the doctor in a year. And a big smile comes to the adjudicator's face, and he says, no problem, Joe, I'll send you to one of ours. And a Social Security consultative examination is get on the table, get off the table, walk heel to toe. How many fingers am I holding up, and what's the difference between an apple and an orange? And it's never going to prove chronic pain or fatigue or impaired concentration, and your benefits are going to be terminated. So what's the rule? You must be going to the doctor. That is the key. There are good return to work incentives. We're not going to have time to go through all of these. The material is in the handouts, and we can also answer questions. You can also find a lot of information on our website, rkblegal.com. I'm also honored right now to be the current chairperson of the National Alliance on Mental Illness in Dupage County here in Illinois. And one of our lawyers, Spilios Bakuyanis, is the current chair of the Chicago Bar Association Social Security Disability Committee. He's a very good, bright lawyer with a good future, been recognized already by the local community, and I'm very proud of him. Thank you for attending today. If you are a social service professional, if you're a social worker or you run a support group, or if you're a physician, email you can't give me your card, obviously we're virtual. Please email your information for a mailing address. We do this by snail mail, but we do send out a monthly newsletter. There is my information. And I want to thank Jim and Alexis and his team for doing an incredible job. It's so complex to put together a nationally based conference, and this has come off like clockwork, and I appreciate the ability to be part of it. And I have no idea how to get out of this screen share and see if I have questions, but Alexis or Jim can tell me.
All right, we do. I'll give you them as received. quote, if I live in a state that has an accidental disability retirement, workers' comp, am I entitled to SSI, and which should I try to get first? My understanding is that they could consider any settlement as income.
So let's be careful first and distinguish again between SSI and SSDI. So SSI is asset and income based. So if you're getting TTD benefits on your workers' comp, you're not going to be considered indigent for SSI purposes. Workers' comp TTD benefits do not impact your SSDI eligibility because SSDI is an insurance plan. However, your workers' comp benefits do impact the amount of Social Security you get because they do not want you to be getting more money from workers' comp and Social Security disability than you are making working. There's no reason or no incentive then to ever get better and return to work. It gets very complicated. The key here is, number one, workers' comp is always faster and usually easier to get, and it pays you way more than Social Security will, depending on your state. So you always want to pursue that first, and then we try to work out the workers' comp integration issues as we go along with the disability case.
Okay. This is already have Social Security. She didn't distinguish which, but wonder if they cover health aids.
Well, so Social Security only provides cash benefit and then access to the different health insurance systems. So if you're getting SSI, you'll be eligible for Medicaid in your state. Every state is different. So whether it covers home health aides, I wouldn't have a way of knowing. If you're on SSDI and getting Medicare, sometimes depending on your level of benefit, you can get Medicaid as a supplement to Medicare, which actually turns out to be pretty effective health insurance package. Medicare has limits on home health aides. So again, that's a little beyond my area of expertise. You just have to work that out through the health insurance professionals and through most of the home health care services know what Medicare and Medicaid in your area will provide. And if you contact them, you'll get a much better answer than I'd be able to give you.
Appreciate that. And I think we answered this in your introduction, but people might have come late. Have you represented anyone for federal disability for an appeal?
So federal disability, that can mean one of two different things. We've done many cases into the United States District Courts, mostly here in the 7th Circuit in the Chicago, Wisconsin, or Illinois, Wisconsin, Indiana area because it's a more favorable area. But we team up on the federal level with lawyers all over the country. There's a different program for federal workers' comp. That's a nightmare program that I don't know any lawyers in the country do. I think I heard of one guy in Washington State that does them because there's no way for an attorney to get paid to handle those cases. So I don't know anybody that handles federal workers' comp cases.
Yeah. It's very difficult to find out, but we will try to do that. I have another question. I have CRPS in the past 5 years been denied 2 times for Social Security benefits in spite of 2,500 pages of document explaining my doctor's opinion that I cannot work even part-time. I've had the assistance of attorney for the second claim, also denied and appealed and denied again. I understand there's a time component and I may be passing the time of consideration. Is there any further process or appeal that makes sense?
Well, again, you'd have to talk to whoever your representative is. But if we take a case, we generally commit to that client that we're going to go all the way to at least the appeals council. There's more jerky judges now than there ever have been in the past. And because we had, and I don't mean to be political here, but we had 7 or 8 years of very conservative leadership in the House of Representatives under Paul Ryan from Wisconsin, and he hates this program. And he did a lot of damage to this program during that time. And nationwide, the approval rate has dropped precipitously in all cases. So we commit to our clients, unless something unusual happens, we're going to go to at least the appeals council if we lose in front of the judge. And in many cases, we will go into federal court. So just the fact that you've lost doesn't mean that the case is over. And I would work with your representative to see if you can go into the appeals council or federal court if you still have time. And you are correct, at some point your insured status under the Social Security Act ends because it gets so long since you've worked and paid into the system that you can no longer keep filing. So I would look at your last application. If you're still within the appeals period, I would talk to your representative that handled that and see if you should go into the appeals council or federal court. Never ever let an initial or reconsideration level denial be determinative. Those are paper reviews and are half-assed kind of meaningless things.
Let's just specifically talk about CRPS. Someone's asking how difficult it is. I know you talked about symptoms affecting the work, not the diagnosis itself, but could you give any guidance here?
Sure. So CRPS cases are tough. And first of all, let's be realistic. Not everybody with CRPS is totally disabled. I mean, a good example is my wife had CRPS and suffered really badly, but we caught it early because I was aware of it, and she was able to return to work. So the diagnosis isn't the focus. The focus is on the chronicity of the symptoms and what the medical charts prove, how those medical charts prove the symptoms impact your day-to-day life. So one of the things that's actually changed over the years, Jim, is we now get hired way earlier in the process. I'd say about 90% of my clients now come to me before they've even started their case, which is great because we then get to have this discussion with them. We make sure they're seeing the right pain specialists or the right neurologists. And if necessary, we convince them of the importance of seeing a counselor with a psychiatrist or a good PhD psychologist. We explain to them how important it is to document their day-to-day life and limitations. And that's how they build the charts up. The earlier we get involved and explain that to them, the more evidence there is in those charts and the easier it is to win the case. So because these are not what they call objective evidence cases, I can't point to a test like a pulmonary function test. Somebody comes to me for a breathing problem, they go to a pulmonologist, they blow into a machine. Science tells Social Security if they blow 1.5, they lose. If they blow 1.4, those lungs are so bad, pay the benefits. There's nothing like that in a CRPS case. So we have to do this longitudinal, week after week, month after month, therapist, psychiatrist, pain doctor, neurologist, orthopedic, internist, consistently over all these records, and that's how we prove a case.
Okay. What about, in the beginning, you gave the average delay for getting approved. What that was an astronomical figure. I wrote down something like 60-something months. Is that?
No. 6 right now. So again, I had to skip some of this because of time.
Yeah.
So the first level of review we call the initial application level. And that used to be 90 to 120 days. It's now about 180 days or more. So about 6 months to get through the first level. Second level, reconsideration, again, used to be 120 days. It's now expanded out to 4 to 5 months. Third level is a hearing before a judge. Now that time frame is actually decreased because as cases are getting held up more at the first 2 levels, judges are getting less cases. So I was talking to a friend of mine in Toledo, Ohio today. Her judges are scheduling hearings 4 months after they get the case. In our Chicago offices, it's still about 6 to 8 months after they get a case. Many, many years ago, when I got a case at the hearing level, I would tell people it would take 2 to 2.5 years to see the judge. So they put a lot of money and resources into knocking that backlog down at the hearing level, and they've been successful at it. Now the backlog is at the initial and reconsideration levels. But general rule, we tell people 1.5 years to process a case from application to completion. It's getting extended a little bit because of COVID now, so maybe 1.5 years to 2.
Okay. 2 more questions. Does it help your case to have multiple diagnoses, let's say asthma, et cetera, along with CRPS, that complicates your medical picture?
Every condition is considered, so the answer is yes. Some are not as severe, so you can have asthma, but if it's basically, controlled by medication and you're not in the emergency room with a lot of asthma attacks, it's not going to be a major function in a disability case. But we ask every client to describe every medical problem. Migraines are often a secondary problem that actually become really totally disabling. And very, very frequently, the mental health issues become a critical secondary impairment that impacts concentration and focus and the ability to sustain activity. So if we can get treatment notes, that mental illness is a secondary issue. But a lot of people come to us, and in addition to their primary problem, they have thyroid issues and high blood pressure and type 2 diabetes. Those are all serious medical problems, but they're not going to play a significant impact in the outcome of the disability case.
Okay. So I think that's people network too. But 2 things. I'd love for you to send me your slides, because these videos and PowerPoints will not be up until the first week in November. So if you could do that afterwards. And second, I just want to thank you, Jeffrey. You could have gone on for 4 hours. I mean, you're tremendous.
Thank you.
And I hope you.
Thank you. I love what I do. I'm very blessed. And Jim, working with you and the dedication you have shown this community for all these years is a privilege.
Wow.
And I respect what you do. So anything, you have my name and number there. We answer questions all the time for free. We don't charge to answer questions. We are representing people for right now nationwide, because COVID and telephone hearings have made that possible. If people just have issues, I'm willing to help. I can't interfere with other lawyers. That's not ethical. But I can just answer general questions, and I have a great staff and really good intake people, and you'll enjoy working with them.
Okay. Finally, for everyone in this session, please register for the next sessions. We had to split it up just because of the social platform. So again, Jeffrey, we're going to say goodnight and feel better.
Oh, I'm fine, and I apologize for all the coughing and stuff. And if there's anything I can do to help, let me know. And Jim, thank you again for all of your work on behalf of this community.
It's a vocation. I love it. Take care.
All right. Take care, everybody.